You're good, Rose Green? Do you want to continue your hearing today, or do you want me to push you out 2 weeks?
No, push me out in 2 weeks, yeah.
You want a hearing today?
Yes, today, please.
Okay.
All right, everybody, buckle up because we're in for another wacky Connecticut parole hearing. Don't drink the water, guys. That's the #1 rule and advice I can give anybody living in or traveling through Connecticut. But before we watch this hearing, what we're going to do is take a blast to the past to see how it is that we even got here. So with that, let's jump in. And remember to check out the Return of playlist if you'd like to see other parole hearings where we connect present, past, and future hearings together.
Good morning.
Good morning, Mr. Rose Green.
Please state your name and inmate number for the record.
Lamont Rose Green, inmate number 279798.
This hearing is being conducted in consideration of the parole application for Lamont Rose Green, inmate number 279798. He is serving a sentence of 10 years jail, 3 years and 9 months to serve, followed by 3 years of probation for 2 counts of criminal possession of a firearm, ammunition, defense weapon, and threatening first. As of today, records reflect a parole eligibility date of September 30th, 2024. There is no victim input in this case. There is an offender accountability plan for the offender. It has been reviewed, shows the offender has completed voices. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score falls within the very high range of risk for recidivism. Mr. Rose Green, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
So, I believe I should be granted parole because, I don't feel like I'm a harm or a danger to anyone other than, the things that I have done, which basically pertains to me. There's certain things that occurred during these circumstances that I can't fully explain in the totality in which I think people could resonate with me because they was indicative to me and they was ongoing while I was going through a situation in my life and trying to get an understanding about stuff and not really getting straight answers from people as to how I was going about my life. So I don't think I'm fully answering the question as to why I should be granted parole.
Not make sense.
And I'm at a loss of words a little bit right there for that because that's a very strong question given what I'm charged with and things that, and it's I want to say it's hard to it's not hard to answer that. I would just want to say, yeah, give me parole. But it's hard to answer it given and understanding the totality of all of what encompasses me being charged with.
All right. So, Mr. Rose Green, why do you think you'd be successful on parole?
To be successful on parole, I feel as if understanding now what I didn't understand before, I have a lot more options. Options as to saying how I understand what leads me to get to my thought processes. And what led me to get to these thought processes was thinking that I could shortcut things and thinking that I would have a grander life instead of doing things the appropriate way.
Okay. All right. So we're going to ask you some questions. So maybe by our questioning, we'll be able to dig a little deeper into why you think you would do well on parole.
Okay.
Or why do you think you've earned the right to go out on parole?
Okay.
Right? Because it's a privilege.
Right.
Okay. All right. So, Mr. Rose Green, Mr. Dargan is going to begin with the questions.
Thank you, Madam Chair. Good morning, sir. How are you?
For the most part, I'm all right. I'm all right. Thank you.
All right. So, my colleague asked you, about parole. So, there's a lot of things we look at, right? So we look at your prior track record where prior parole or community release, you had a number of failures over the years, like 7 or so. So how do we get you onto the right track, so to speak?
Okay. Onto the right track. Things that I have partaken in while I was on parole would be certain programs to better myself, like, they had training programs. I partook in those. I was successful at those at a part of time and for a period of time. And for the most part, things were working out, but it's just certain transgressions, like things that I couldn't control and foresee, and understanding that I needed help at the time and not had these, and I didn't have the right things around me to keep me focused on what I needed. So when I say that, I took training programs, like, they had something that the North Star program, and I did that and I accomplished that and I did the things and I got a job and I started working. It's just other relationship problems and things come into focus that, that really doesn't have anything other than to do with my thought process, So at the time, I thought that I could fix things by partaking in other things that didn't help me at all, in a sense. And then I get to the rabbit hole of thinking that I could just fix it by just doing these things real quick, and it just all turned awry.
So in a short period of time, you had 2 offenses with a weapon, right? Criminal
Yes.
possession of a weapon. I read in the interview with the parole officer that you stated that you were in a bad situation. You're caught with 2 firearms, and then you went on to talk about you thought something was going to happen to a family member, right?
Right.
And so those 2 gun issues are concerning to me, because what's going on with society, right? Everybody's, shooting up everybody, and, that was somewhat of a concern to me. And then, I looked at programming and what you've been able to take, and have you just recently finished Voices too?
Yes.
Okay. And has that been of help to you to understand maybe what was going on?
Yes, so to speak, and to speak a little bit more in depth about, as to how I communicated with Officer Trissillo about, me hearing these threats that was going on. And that was just a small increment part of what was transpiring all around me. Being around certain individuals, it might not always be your own doing, but the fact that you around these individuals, that is of your choice, and understanding that certain people not going to tell you all of what they're doing. So when you coming into the realization as to what's going on, and it's dramatically happening, and it's transpiring all in its totality, it was a lot. It was very overwhelming. And when trying to communicate with this person, I get that narrative from them that, this is going to happen. It was just so impactful at the moment, and understanding that all of what could have transpired, and trying to communicate this to somebody and being able to get away from the situation. I was already too involved. I was already too much in the cauldron of what was happening. So it wasn't when I tried to take a step back and not participate in what was transpiring, it wasn't feasible for me to do. It wasn't feasible in the sense where I couldn't just basically sit on my hands. Even when I would try to avoid individuals, it kept coming to be in my presence. And not to say that I wasn't participating far as being around, but I wasn't participating in the action that I wasn't aware of. Just being around the individual would have had it assumed that I knew the full totality and what they was going through. But being involved, I would say, knowing firsthand everything, I didn't know all of what was going on. Just when I got that narrative, I figured nothing could fix immediately what was going on. So and then that was the bad choices that I partook in having them pistols. Like, it just, not that but it just didn't, I seen no other way out of having a pistol. Was I trying to cause individuals direct harm? No, I was trying to prevent harm from being caused to my loved ones and individuals. And in the process, I know I'm not supposed to be moving around with these things or even having them. It was really.
Okay, so let me ask you this. So you went on and you thought that you have to deal with better coping skills. You want to talk about that for a moment?
Yeah. So dealing with better coping skills and getting that somewhat out of the program. Yeah, I need to more or less make better decisions overall. And that's just even dealing with the people that I thought that I was comfortable with or that I thought I knew. Maybe what you see on the surface is not all of what they do when they're away from you. So now getting that into my thought process from me sitting and doing the program and getting to interact with other individuals that's in here, whether it be that they positive or negative, I see that, yes, I do need better coping skills. I need better skills in which that don't lead me to think that I can help somebody more than what they're willing to try to help me. I need to worry about me first and what I need to get situated, because thinking that you're friends with somebody and that's not gonna keep you from possibly making a bad decision when the right decision is to possibly just get away from everything.
Okay, so let me try to sum this up here. That back in 2022, you got a couple of fighting tickets, right? And then earlier this year, you had a stinger, right, with a cord, right, for some sort of food. Okay. So I read that too, and I know you have a number of years. Well, you have 3 years of probation to follow. You have to register with the Deadly Weapon Registry. Where else do you think you might need some help in order to be successful?
Education, so I can have more options to do better and find me a better sustainable job other than trying to get back out here and think I can make a quick dollar. Possibly possibly so, even though I'm ashamed to admit it, I might need some counseling too. So yeah, might need some counseling too.
Okay, so it looks like with substance abuse, you said you drank once in a while, but basically you're smoking weed a few times. It was laced with cocaine. Is that accurate?
Unbeknownst to me, it's probably released with cocaine, but I never had that conversation with an individual, I don't believe. But if that's something you have right there, I don't know how that got to be that situation.
Okay. All right. Well, thank you very much for answering my questions.
Okay,
And thank you, Madam Chair.
thank you. Mr. Rosgreen, just give us a quick minute.
Recess.
You want to recess or you want to go into
No,
executive session?
the recess, I want to discuss that.
Okay, Mr. Rosgreen, can you give us just a moment to have a brief conversation?
Okay, you want me to
No,
step
you
up?
stay right there.
Okay.
Can you move this for a second?
You gotta get her to come in.
Yeah, that's okay. So, Mr. Rosegreen?
Yes.
Are you there? So we want to ask you some more detailed questions about your mental health. So we're going to go into what we call executive session so that we can have a conversation that's not live streamed to the public.
Okay.
Okay, so can you so you stay there for 1 minute while we work that out.
Okay.
Thank you.
Can you grab the CO for us? This screen, please.
I didn't hear all of what you were saying. You were
Can you
breaking.
grab the CO for us quickly?
Okay.
The officer.
They told me to tell you.
What happened? He wants to get the CO.
Oh, okay. I'm okay with it, honestly.
Are you?
Oh, yeah, yeah.
Hello?
Good morning.
Morning, is he all set?
Let's talk about.
I'd like to talk to him in private, not on the live stream. So I'm gonna walk you through the steps to disconnect and reconnect and then. So the board does still need to speak with him, but we're just gonna do it off the live stream.
Okay,
So if you haven't come back in the room, on your end, you can press the red hang up button. And then about 60 seconds, you're gonna get a new invite that pops up on your screen and you can press accept.
okay,
Thank you.
okay, sorry.
Thank you. Thank you. You are connected back.
We're now out of executive session and back live with Mr. Lamont R DOC.
All right, for the record, the chair failed to make a motion to go into executive session, however, did make a note on the record that we were leaving the live stream to go into executive session to ask questions. We're now back. All right, so Mr. Rosegreen, we're all done with our questions for today. So we are now going to deliberate about your case and make our decision.
Okay.
And we'll give you our decision in a moment.
So,
All right, Mr. Doggett.
you know, he had 2 criminal possessions of a weapon in a short period of time. He got 3 years and 9 months. He has 3 years of probation to follow. It looks like this is his 3rd prison sentence. He has a number of failures, a number of DRs. He has to register with the Deadly Weapon Registry. The programming took voices. My concern with my notes were with his eligibility date of September was that I thought he needed some additional programming. You know, that's one option, or to go to end the sentence, which is, you know, like 2 years out.
Yeah.
So I thought it, you know, again, not being eligible to September, that he might need additional help prior to his release. So that was kind of what my overview was, and I'm happy to listen to my colleagues to look at what we think the best opportunities are for Mr. Rosegreen to be successful.
Mr. Rodriguez.
Chair, I would agree that Mr. Rosegreen needs additional programming, additional services.
Well, and what services were we thinking that he would benefit from?
Well,
Maybe
he hasn't taken the additional services
this is
here
true.
yet, so that would be something he could get into while he's still there if we decide to let him out in September. But yeah, that would be, in my case, just see him a little bit more programming, and then
Okay, he does have a drug and alcohol score of a 4.
Right.
He's a mental health score of a 2.
Yeah, and it looked like he just used marijuana.
Exactly. Yes, and he had a medical marijuana card
Right.
at some point. I am looking at his criminal history. He's got a number of sales convictions. He's no prior, and he's no prior conviction for anything of violence. He was cooperative throughout, I think, the interview to the best of his ability. He does have the disciplinary reports. He was actually early terminated from his last period of special parole, so he must have been doing well in compliance. He does have reports that his mother is doing well, and he can release to her house. And I'm going to tell you, I'm not sure. I think he could benefit from an addiction services program. I do feel like he could benefit more from mental health treatment in the community while he's on parole.
I'm sure I would agree with that.
I'm in a place right now where I'm not sure that his mental health needs will be addressed with a longer prison sentence. Not that he does score high, but I don't see any prior violence in his history or some technical violations. He has some struggles on community supervision. I might be inclined. He got an excellent evaluation for voices, so he obviously participated well in that program. He served 2 years and 3 months of his 3-year and 9-month sentence. I would not be opposed to granting his parole today.
I think he has time between now and September to get something in, additional programming in. If not, addiction services, good intention, bad choice, or something that, kind of just give him some more.
So do you want to bring him back in September and have him do those before he's paroled, or do you want to make him eligible for parole on or about September?
I think he needs help in the community as well.
Mr.
Yeah,
Doc?
I mean, I don't have them released early just because of the 2 criminal weapons possession in a less than a 2-week period where he received both of those charges. And I thought he lacked in programming, and so that's kind of where I'm at.
So do you want to bring him back after more programming, or do you?
I would be willing to go to get services in the community.
Okay.
Services.
All right.
But he's not going to get.
Yeah, I mean, I don't have
It's not-
I had notes to bring him back that go to end the sentence. But
Okay, so I'm going to make a motion to grant parole on or after his date. So in the matter of Lamont Rose Green, inmate number 279798, I make a motion to grant parole on or after September 30th, 2024 with the following conditions: halfway house placement if necessary, mental health evaluation and treatment as deemed necessary. And that's all I had. There are no co-defendants and no victims. But do I have a second?
Second.
All those in favor? Aye. Those opposed?
I,
Okay. Mr. Dargan is on the minority, and the motion is granted. All right, Mr. Rosegreen, we granted your parole, which you're eligible for in September. And did you hear the conditions that we would like you to abide by while you're in the community?
I believe it's some mental health treatment. And then totally grasp everything else because you
Yeah.
got.
And if it doesn't work out that you can live with your mother, we've added a halfway house in the event that that's necessary.
Okay.
Okay?
Okay.
All right. So best of luck to you.
Thank you very much. Have a great day. We done, I believe, or
You're done, you can leave.
thank you.
And they granted parole. What could go wrong? I think if there's any guarantee, it would be that we would never see Mr. Lamont Rose Green again.
Morning.
All right, good morning, good morning.
Morning, Mr. Rose Green.
Yes,
Okay, we're gonna get started. We're gonna get started in 3 minutes. I just have to wait till 10:45 and then we'll get going with your preliminary hearing, okay?
okay.
Officer Davis.
Go for PaRoLe, Davis, P.O. Meisinger. We're online streaming right now and I have Mr. Rose Green here, as well as Attorney Dean. Are you ready to begin?
Yes, I'm ready to begin.
Okay. All right, we're gonna get going, Mr. Green, and start, okay?
Okay,
Here on,
Obedience to law on 12/12/24. I mean, if you can't find it, I can read this part. It's fine.
I got it. I'll read it. I just found it.
Okay.
This is the part I left out here on charge number 5, obedience to the law. I just missed the paragraph. I'll read now. On 12/12/2024, upon arrival to the Hartford District Office, you were observed via video camera footage opening the door to the office. In the entrance way, an employee of Hartford District Office Maintenance and Custodial was performing his daily job duties. This employee is contracted through Easter Seals, which is a company that employs disabled and mentally compromised individuals. You were observed physically putting your hands on this employee and moving/pushing him out of the doorway. You obviously frightened said employee because he immediately put his hands up and wanted no part of getting in your way. After pushing said employee outside, you were seen entering the elevator. You then exited the elevator and kicked the wooden door by the entrance and proceeded upstairs to the lobby. Based on your behavior, you were in violation of breach of peace, Connecticut General Statute, Section 53A, 61A, assault in the 3rd degree of an elderly, blind, disabled, mentally retarded, or pregnant person. That's the part I left out. Sorry about that.
Okay, thank you. And the state filed the following exhibits pre-marked for identification purposes as Exhibit A, CT sign remand extra custody order. B, CT sign conditions of parole. C, notice of parole violation with offender rights. D, parole violation report. E, PCS misconduct reports, which includes the Allied Universal EM manager. F, CT decision information summary. G, GPS monitoring agreement paperwork. H, pre-sentence investigation report. I, discharge paperwork after a visit summary from Hartford Hospital. J, 2 disciplinary reports received 12/13/24. K, video and pictures. L, staff witness statements. And M is Connecticut General Statute printouts. Did you receive the notice of parole violation report, and those other documents I marked, and did you review them, sir?
I'm a little confused with keeping up with all that.
Did you receive the evidence I just read?
I received some paperwork and I didn't have the full time to go through everything, so. But some of what I'm hearing it sounds correct, and then some, I
Mr.
know.
Rose Green, I wouldn't say anything as to the allegations here. They're just asking if we received this evidence and had an opportunity to review it, which I have done. So I just want to make sure you got the paperwork too, correct?
Okay, yes.
Okay, thank you.
I need to continue this hearing containing additional evidence.
No, thank you.
Okay, we have no witnesses. So I'm going to swear in both Mr. Rose Green as well as P.O. Davis, so that if you do choose to speak today, you have to be sworn under oath. So can you please raise your right hand for me? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give for in this case should be the truth, the whole truth, and nothing but the truth, so help you God by the penalty of perjury?
I do.
So at this time, you can put your hand down now. The state will have an opportunity to make a short statement and testify with respect to probable cause for the of the allegations. So P.O. Davis, would you like to speak?
Sure. Just in opening, I'd like to just say a couple of things. For almost a 36-hour period, Mr. Rose Green was a menace and danger to himself and society. On 12/11/24, Mr. Rose Green showed up to the office after I did a home visit about 3 or 4 hours prior to that. Mr. Rose Green stated he didn't have any issues, but he showed up later that evening on 12/11/24. When he showed up, he was acting erratically in the street, blocking traffic, and people trying to get, to and from work, publicly displaying his genitals and acting uncontrollable. At that point, he was EMS took him to the hospital, and police were also called. That continued the next morning. I called in, back into the office to see, what was going on and what transpired the night before. The non-compliant behavior begun again in the office that morning. He disrupted the whole flow and operations of the office, cut his GPS off and threw it, and we had to clear out the lobby of other offenders at that time. EMS was called again, fire department was called. He was then again transported to Harvard Hospital, where again, the non-compliant behavior began, assaulting staff, being non-compliant with doctors and other medical staff, trying to kick and assault patients that were in the hallway of Harvard Hospital. So again, the non-compliance in the hospital as well. Last thing I'll mention is when we did drop him off to Harvard Correctional Center, it was without incident. However, he did the next day on 12/13/24 receive 2 disciplinary reports for interfering with safety and security and insulting language and behavior on 12/13/24. That's all I'd like to say for that. Thank you.
Thank you. All right, it's now defense's opportunity if you'd like to speak at this time.
Yes, thank you very much. As to charge 1, I don't have any comments as to the probable cause standard. As to charge 2, curfew, no comments to probable cause, but I do just want to note the alleged late reporting for the curfew. On each of those occasions on 10/26, my client was allegedly only 12 minutes late, and on 10/28, my client was also allegedly only 15 minutes late. As to the third requirement, drug testing, I would argue that the probable cause standard has not been met. We don't have anything in evidence indicating that my client refused to submit a urinalysis, either at the parole office or at the hospital. In fact, the discharge summary that's included at Exhibit I from 12/12 is silent as to whether urinalysis was taken or attempted. So I would argue that the standard has not been met for that charge. For program participation, I would also argue that the probable cause standard has not been met. My client does indicate that he was engaged at Wheeler Clinic at some point during his parole supervision doing groups there. And I would just argue that no evidence has been submitted as to that charge. As to 5, obedience of the law, I also broke this into 3 separate parts. As to the first part, I would, for all 3, argue the standard hasn't been met. As to the first part, I would just note that the incident on 12/11, my client was not arrested despite the police being called and being present on scene. That is the standard probable cause that they typically use for arrest, and it was found that my client was not appropriate to be arrested at that time. So I would argue that the standard has not been met. I would also argue that as to Exhibit K, the photos and evidence are not time-stamped. So it's difficult to provide context as to when those photos were taken, what they are taken of. So I would ask that as to that charge, they not be considered for evidence. As it charges, second part of that charge and charge 3, or part 3 of that charge, I would argue for each no finding should be made. No evidence was submitted as to part 2, my client allegedly assaulting this individual. There's nothing in evidence to support that. And as to charge 3, that incident on 12/12, we don't have that specific information or video and evidence or any signed statements from that date as to substantiate those allegations. So I would argue that that standard has not been met. And as to charge 6, I would also say that the standard hasn't been met for that one. No evidence was submitted as to my client refusing a search. So I would make those prior arguments. Thank you very much.
Thank you. So based on the information that I have testimony provided, I am going to announce my findings. So regarding charge 1, I make a finding of probable cause, release direction GPS based on evidence that was presented, exhibits B, E, and G. I make a finding of probable cause on charge 2, release direction curfew based on the evidence that was presented, which is exhibits B, E, and G. Regarding charge 3, condition release direction drug testing, making no finding of probable cause based on there being insufficient evidence to support this charge. There's no evidence the offender refused a drug test. On charge 4, condition program participation, and making no finding of probable cause based on there being insufficient evidence to support the charge. There's no evidence that the offender was not participating in a program or anything in regards to that. On charge 5, I make a finding of probable cause obey all laws, obedience to the law based on evidence that was presented in support of the violation. This is exhibit, part 1, KLM, part 2, KM, and part 3, KM. However, on that part 3, the part at the hospital, I make a no finding on. So this is only for the 12/12 while the offender was at the Hartford District Office. So it's kind of like a sub. Regarding charge 6, a search, I make a no finding probable cause based on there being insufficient evidence to support the charge. No evidence the offender can use a search anywhere. So but I do find the act is serious enough to warrant revocation. Attorney should be detained while you wait for revocation hearing. So at the rev hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or be sanctions should be imposed. So we're going to bring you back, sir. This is a technical violation. So 60 business days we have from your date of return to custody to hold a revocation hearing. And then we determine if there's a parole violation or not, and if any sanction is going to be imposed. Okay, so we're going to bring you back and we'll talk to you and determine what's going to happen, right?
Okay.
And I will meet with you once more before that hearing so that we can prepare for it, okay?
Okay.
P.O. Davis, would you like to be at the revocation hearing?
Yeah, sure.
Okay. Okay. All right, so what else set for today then?
Thank you very much.
So thank you. Have a good day.
Take
You
care.
Have a
too.
good day, everybody.
Thank you. I can go.
Okay, so as we see, it didn't take long for him to find his way into trouble. And this time it seems that he has some violent acts going on. Like the parole board said, well, he hasn't had anything violent in his jacket. And look, we're going to go see his official revocation hearing. What we just saw and what's interesting of what Connecticut does is they record the whole preliminary hearing where then they decide what actually can be held against him and what can't be. It's like a legal proceeding. It's really interesting that Connecticut does this, and also very expensive, frankly. I mean, keep in mind, every single person who shows up to revocation hearing automatically has a defense attorney. So you have the preliminary hearing with the defense attorney. The parole officer has to sit there and document everything at like a legal standard. It's unlike other states like Louisiana, it's almost impossible to get representation given to you by the state. But anyways, we've seen all 3 colors, beige, green, and red. And that's what we're going to see now is the green.
Right now.
Let's see what happens.
All right. Is he like okay enough? I mean, can he understand things?
Should be able to, what's up? She wants to know, is he okay enough to?
Is he gonna
Hi.
understand? Hi.
How you doing?
Good.
What was that? I'm sorry.
I said, is he able to understand everything?
Yeah, he should be, yeah.
You're good,
I think so.
Rosary? You want to continue your hearing today, or do you want me
Yeah.
to push you out 2 weeks?
No, you push me out in 2 weeks, yeah.
You,
Oh,
you
yeah.
want a hearing today?
Yes, today, please.
Okay.
Just have a seat there, right?
Okay.
Do it like this. If they need anything, we'll switch out this, because if they need us to, okay? We'll be right here. I'll say,
Thank you, guys. All right,
No problem.
Mr. Rosary, all right, so we're gonna start your revocation hearing then, okay?
Okay.
Today's video is sponsored by Aura. Did you know companies can take months to report a data breach? On average, it's 277 days before you even find out that your personal data has been exposed. Think about that, 277 days. That means that your sensitive information like your email, your phone number, even your financial details can already be out there. Now, it's not just one company, but major banks and corporations, they've all experienced breaches in the past year. Maybe you've seen about it in the news. Your information could be compromised right now, and you wouldn't even know it. Now, that's why I use Aura. Aura scans the dark web and alerts me fast if personal information has been leaked. If someone tries to open a bank account or credit card in my name, I'll know right away. I have been using Aura for about maybe 9 months now. Something that they also do that really helps me a lot is keep spam callers away. That's a big bonus for me. They actually remove my name from those spam caller lists. Now, they also provide up to $5 million in identity theft insurance and a full suite of tools to keep you protected. And this is it's all done in one app. You can try Aura for free for 14 days at aura.com/Mandoo. And that's 2 weeks to find out if your data has already been exposed before you hear from a company months later. So why wait? Get some peace of mind and try out Aura for free. Take control of your digital security right now. And now let's go back to the hearing.
And P.O. Davis, you're here.
Yes, I'm here. Good morning.
Okay, so we're going to get started. So good morning. I am P.O. Meister, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rose Green Lamont, number 279798. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Rose Green. I'm not Lamont Rose Green. 279798.
Thank you. And we have a parole officer present. Can you please identify yourself?
Parole Officer Patrick Davis. I work out of the Hartford Parole District Office.
And we have counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Mr. Rose Green. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure, Rose Green?
No.
Okay. Your important rights today, the right to have an attorney present. You have counsel here. You have a right to receive the written notice that charges the violation. Did you receive the written notice?
A while back, but I wasn't able. Okay.
Yep. You have a right to view the evidence against you. You have a right to submit evidence for to your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so now review the charge, state your PO is bringing against you, and the information underlying each charge. So PO Davis, if you can please read, that would be charge 1, charge 2, and charge 5. Charge 3 and 4 and 6 are not taken into consideration as no findings were made at the time of the prelim.
Sure. Charge number 1, GPS. On 8/6/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 12:38 a.m. to 7:14 a.m. And again, that same day from 10:26 p.m. to 8:27 a.m., 8/9/2024. This is a violation of your signed GPS agreement. On 10/19/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 8:02 p.m. to 12 a.m., 10/20/2024. This is a violation of your signed GPS agreement. On 11/20/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 1:08 a.m. to 8:32 p.m. 11/21/2024. This is a violation of your signed GPS agreement. On 12/12/2024, you removed your GPS unit without permission from this officer. This is a violation of your signed GPS agreement. Charge number 2, curfew. On 5/1/2024, you were instructed of your GPS curfew of 9 p.m. to 6 a.m. At no time were you provided with any other curfew or given permission to be out past your curfew. On 10/26/2024, you did not return home until 9:12 p.m. This is a violation of your signed GPS agreement. On 10/28/2024, you did not return home until 9:15 p.m. This is a violation of your signed GPS agreement. Charge number 5, obedience to the law. On 12/11/2024, at approximately 4 p.m., you arrived at the location of 300 Sheldon Street, Hartford, Connecticut, 06106 HDO. You were acting erratically. Your behavior suggested you were having either a drug-induced or mental health incident. Parole officers responded to the scene and requested HPD and EMS due to your behavior. You were observed blocking traffic in the intersection with a parked vehicle, running out of the vehicle and attempting to run onto the adjacent highway, I-91 exit ramp, not listening to verbal commands or instructions, speaking in a way not to make any sense, crawling and exposing yourself and making lewd gestures to multiple responding staff members and those in passing cars that were unable to leave the scene due to your blocking of the road. It was determined that you may be a danger to yourself and society. EMS transported you to Hartford Hospital without incident. Once you were there, you were uncooperative with hospital staff and were discharged due to your non-compliance. Your behavior is a violation of breach of peace, Connecticut General Statute, Section 53A-181, and public indecency, Connecticut General Statute, Section 53A-186, Exhibit M. Want to make sure I'm reading the right one here. On 12/12/2024, upon arrival to Hartford District Office, you were observed via video camera footage opening the door to the office. In the entranceway, an employee of Hartford District Office Maintenance and Custodial was performing his daily job duties. This employee is contracted through Easter Seals, which is a company that employs disabled and mentally compromised individuals. You were observed physically putting your hands on this employee and pushing him out of the doorway. You obviously frightened said employee because he immediately put his hands up and wanted no part in getting in your way. After pushing said employee outside, you were seen entering the elevator. You then exited the elevator and kicked the wooden door behind the entrance and proceeded upstairs to the lobby. Based on your behavior, you are in violation of breach of peace, Connecticut General Statute, Section 53A-61A, assault in the third degree of an elderly, blind, disabled, mentally retarded, or pregnant person. On 12/12/24, you reported to the Hartford District Office. Upon arrival, you were observed in the elevator of the Hartford District Office acting strange and attempting to take your shirt off. Once in the lobby of the Hartford District Office, you began your non-compliant behavior by making other offenders feel extremely uncomfortable for their safety. You were forcefully moving lobby chairs around, raising your voice and screaming. You were then observed ripping your GPS monitor off your ankle and threw it in the lobby that was filled with other offenders. Based on your behavior, medical services were called, and you were once again transported to Hartford Hospital. While in transport to your assigned hospital room, you attempted to kick at other patients in the hospital hallway and knock down the medical equipment attached to them. Once in your room, you used disrespectful language by swearing and using profanity at officers and medical professionals and threatening medical staff to not touch you or render any type of medical aid. Based on your behavior, the staff was once again unable to render any care. You were provided with a urine cup and you proceeded to throw this cup at this parole officer, just missing this officer and hitting another officer in the leg with it. You were provided with a bottle of water, and you once again threw this towards staff, causing them to quickly move out of the way, resulting in it hitting the wall. Your behavior, based on your behavior, you are in violation of breach of peace, Connecticut General Statute 53A-181, disorderly conduct 53A-182, assault of a public safety, emergency medical, public transit, or healthcare professional, section 53A-167C, Exhibit N.
Thank you. And I do just want to make another note regarding the charges that at the time of the prelim, no findings made on alleged behavior during transporting at the hospitals. There's insufficient evidence to support the charge at the time. So I just want to note that that's not taken into consideration at that part. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT remained actual custody order. B, CT signed conditions of parole. C, notice of parole violation with offender rights. D, parole violation report. E, PCS misconduct reports. F, CT decision information summary. G, GPS monitoring agreement paperwork. H, pre-sentence investigation report. I, discharge paperwork after visit summary from Hartford Hospital. J, 2 disciplinary reports received to 12/13/24. K, video and pictures. L, staff witness statements. And M is Connecticut General Statute printout. Did you receive notice of parole violation report, and the other documents I marked? Did you review those, sir?
Me?
Yes. Did you review it with your attorney?
You and I had spoke about that earlier this week when I called you. Do you remember that?
Yes, I remember that.
Okay. And counsel has filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to contain any additional evidence?
No, we don't.
We don't have witnesses today. So at this time, the state will have an opportunity to present evidence and speak to any evidence submitted at this time. I am going to swear in, Ms. Rosary, I know you can't raise your hand. I'm just going to swear you both in, as well as P.O. Davis, in the event that you would like to speak today. So you solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth. So help you God upon penalty of perjury.
I do.
P.O. Davis, would you like to say anything at this time?
Yeah, I'd just like to say a couple of things. I just want to emphasize my concern on how much of a risk to the community and himself, Mr. Rosegreen, poses. His behavior has become increasingly dangerous and volatile, in my opinion. I would recommend that Mr. Rosegreen remain incarcerated for up to 1 year. And since I remanded him back on the 12th of December, he's had 3 Class A tickets. 2 on the 13th of December for insulting language and behavior and interfering with safety and security, and also on 12/31/24 for refusing housing. And he's clearly at Gardner right now on mental health 5 status. I just don't think he's ready for the community as of right now. I think his needs would be better served incarcerated with the potential to get the treatment he needs and deserves. That's pretty much all I have at the moment. Thank you.
Thank you. Okay, I'm turning over to defense. You'd like to say anything at this time?
Yes, thank you. As to the charges, for charge 1 GPS, I don't have any comments. As to charge 2 curfew, I do just want to note that for the 2 violations on 10/26 and 10/28 respectively, my client was only allegedly 12 minutes late the first time and then 15 minutes late on the second incident. So a very minimal proposed violation. As to the obedience of the law, I would argue the standard has not been met. As to the incident on 12/11, my client was never arrested. No warrants have been served on him for that conduct, despite police being called and being present on scene and observing his conduct. My client has no pending cases. Like I said, no warrants have been served. Additionally, it doesn't appear that law enforcement were ever contacted regarding the incident on 12/12, despite the allegations that were made. I also would just note, on both of these occasions, my client did go to the hospital and they failed to admit him despite his ongoing mental health issues, which, I think all of these things are representative of. I do want to comment as to the tickets that the PO brought up. I will just note, both of those tickets were received while my client was not yet at Garner. He, I believe, was at Robinson and then at McDougal, but I think this was before they fully had gotten his mental health situation under control, and he now is at a more appropriate facility. And despite his current level, by all reports from him, I believe he has been compliant with any sort of medication and treatment request. So I did just want to note that in response to the tickets, but those are my arguments. And at the appropriate time, I would like to speak to his background and plans for the future. Thank you.
Thank you. David, is there anything you want to say before I announce my findings?
Me?
No, not you, the parole officer. I wasn't sure if you want to say anything else before I announce my findings.
No, I think I'm good. It's just the 3 tickets, the 3 Class A tickets that is in a short period of time is pretty serious. You know, it raises his level, and you know, it did get him to another facility. I just wanted the 3 Class A DRs are of significance. Yep, that's all I got.
All right, so I'll be right with you with my findings. So in regards to charge 1, I do find you violated condition GPS based on evidence provided, which is exhibits B, E, and G. On charge 2, I do find you violated that condition curfew based on evidence provided, which is exhibits B, E, and G. And as I previously stated, 3 and 4 and 6 are not taken into consideration as no findings were made at the time of the prelim. So regarding charge 5, I do find you violated the conditional obedience to the law based on evidence that was provided in support of the charge, which is exhibits B, K, L, M, D on part 1 and D, K, M parts 2 and 3. I do find that the behavior does meet the elements of the offense. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. Davis, would you like to say anything in regards to future plans for the offender, or anything else you'd like, any other comments you'd like to make before I make a recommendation? Go ahead.
I've known Mr. Rosegreen for a long time. I just want him to get the treatment and the mental health services that he needs and deserves. That's all I have to say.
Okay, let's turn over to counsel.
Yes, thank you very much. My client, Mr. Rosegreen, is 41 years old, born and raised in Hartford, Connecticut. While growing up, he did transition at one point to some group homes in the state as well. His primary support system is his mother, Miss Mitchell. She resides in Hartford, and his older brother, Lonnie, who lives out of state. My client receives support as well from various people he met through the group homes growing up. He also does have one son who is 21 years old. Upon release of special parole in May of 2024, he was sponsored by his mom in Hartford and remained there until his remand in December. He reports that he had done a patient care associate certification about 11 years ago at Goodwin University, in addition to a lead and asbestos certification about 9 years ago. Prior to his incarceration, he was part-time at Will's Auto Sale LLC in Hartford for about 4 months. He also reports establishing 2 businesses. One was an automobile detailing business called WaCkY Down Mobile Auto Detail, and then the other was called A&R Salvage and Recycling. He reports that while in the community, he was participating in outpatient groups at Wheeler Clinic in Hartford. Since being remanded to custody, he reports medication compliance and engaging with a social worker while at Garner. Upon reinstatement of his parole, he would like to be sponsored by his mother, Miss Mitchell, again at her residence in Hartford. He is really concerned about his mom. She is elderly, and he's hoping to help her with daily, requirements around the house. He's interested in learning more about construction and home improvement. He hopes to reapply at the Auto Sale LLC in Hartford, and also to Cheesecake Factory, where he has a history of working in the past. He also wants to build his businesses up and is open to any treatment recommendations, including going back to Wheeler Clinic for dual diagnosis treatment. I will just note again, this is his first remand. He started in May 2024, has been in since December 12th, so approximately 2.5 months. I think that the recommendation of a year is a little steep for this being his first violation, there being no criminal charges that are pending or anything like that. He did not abscond from parole. He was still going. I believe that a lot of these violations are a result of him undergoing a mental health situation. But currently, you know, he is taking steps to try and resolve that while incarcerated. I would just ask for the soonest date that the hearing examiner is able to give him. I will note that it may make sense for him to have maybe the next board date or the one after, just so that he's able to stabilize before he's released into the community. But I do think that that is more appropriate for Mr. Rose Green. Thank you.
P.O. Davis, anything you'd like to say before I make a recommendation?
Yeah, I have to add in a couple things.
Go ahead.
The employment, his two self-established businesses, Wipe Me Down Mobile Auto Detailing and A&R Salvage and Recycling, I had no knowledge of. Never heard of either of those, never received the pay stub. As in regards to the part-time at Uncle Will's Audi, the last time I could verify employment there was 10/21/24. He provided me a pay stub for $630 for 40 hours. So that was the last proof that I had that he actually worked there. And the behavioral health treatment at Wheeler Clinic that was supposedly or reportedly facilitated by Joanna. I have no verification from the treatment provider, no emails that he was attending treatment at Wheeler Clinic. I also asked Mr. Rosegreen during reporting sessions to try to get me proof that he was attending those mental health groups and sessions, and I didn't receive that from him. So on my end, I can't confirm that he was ever in mental health treatment because I don't have any proof or verification. And I asked him for that on multiple occasions. As for the education, I can't confirm or deny that, but he never brought that up to me. Everything else looks fine. Thank you.
Thank you. All right, so I'll be right with you with the recommendation. So I do want to put on the record, I see Fender was out there for about 7.5 months before he was returned to custody. He is on discretionary parole until August of 2026. There are no prior violations noted. No, Fender did receive 3 misconducts. He does have 3 years probation to follow after he is done with his sentence. For our records, he has failed 7 out of 10 releases into the community in the past. As well as noted, he did receive 3 Class A disciplinary reports since his return to custody in December. Did note it is very concerning behavior for safety of the community and the offender himself at this time. So taking all that into consideration, as well as no findings that were made in regards to the violation, I am going to recommend that. Second, give you. I will note the offender, the parole officer did recommend a year incarceration. I'm going to recommend that parole be revoked and that he be reparoled for August 12th of 2025. It's about an 8-month period of confinement as a sanction. I do want to note he is done in August of 26, so this gives him a year left on for discretionary parole before going on probation for 3 years. I recommend the following parole conditions: mental health evaluation,
Okay,
treatment
and
as
there you have it,
necessary,
a
operation
1-year
of motor
sanction.
vehicle, no
And
consumption of
I was
alcoholic beverages, behavior management program for anger management. I'm going to send this to the parole board for March 13th. So on March 13th, the board's going to make the decision. The board can let the offender out sooner, They can also revoke all discretionary parole or make a date later than the August 12th recommended date. P.O. Davis, there's no problem. Do you want me to put halfway house placement on there as a backup, or is the mother's residence okay?
Yeah, I didn't have a problem with the mother's residence, and
Okay.
I actually spoke with her too. Yeah, I don't have a problem with him going
Good.
back there.
Okay, I just wanted to confirm that. So I'm
Yep.
not gonna put halfway house placement on there. And then hopefully the offender can get stabilized and on a mental health treatment plan prior to being released, to whatever date the board does decide. So you're gonna know on March 13th, Mr. Rosegreen, what day the board wants to release you. So the recommended date is August 12th, but they can let you out sooner. Or they can hold you in longer. It's gonna be up to the parole board, but you're gonna know after March 13th. So you can talk to your attorney and you're gonna get something in writing from us. It's gonna tell you what the board decided and what your conditions are, okay?
If you want to call my office after the 13th, we can tell you what the board decides, okay?
Okay, the only
Yeah.
one thing I wanted to discuss was that I'm not receiving my mail on time here. So that's the only thing I wanted to say.
At the facility.
Right.
Okay, yeah, I can, I'm not really sure what we're able to do about that, but definitely let your counselor know, okay? And they might be able to help you.
Good. Get connected with their mental health treatment, sir, so you're better when you go out, okay?
Okay, thank you.
All right, you're all set for today.
Great,
Thank
take
you.
care.
Thank you, P.O. Davis.
Thank you. Have a good day, guys.
Have a good day.
Expecting an outburst, some anger, frustration. I mean, the man just found out that he's going to have to wait a full another year, and all he cared about was the problem he's having with his mail. I didn't expect that, and I was flipping all around the place. I was wondering, is he malingering? Is he kind of like exaggerating that? Because as soon as they started talking about him needing the mental, not going to mental health or whatever, he's like, he seemed to make I don't know. I don't know. I think for no doubt he has issues. That's why the parole board at the beginning had their executive summary, right? Because they were talking about something, but clearly this is, and it was just so interesting. It's like the parole officer, he's like, I just want him to get help. And then you have this defense attorney, which is like fighting tooth and nail. And that's the thing about these public defenders here in Connecticut. They impress me. I mean, they go to bat for their clients, and she's like really fighting hard. And it's just, but it's like, is it really in his best interest? Like, if you won and they said we're not going to sanction him, is that really in anyone's best interest? How do you go to war for your client? And you might bring up a different, okay, well, the problems is that we got rid of our mental institution. So it's either you're in prison or you're, on the street. And that's true. I mean, the U.S. got rid of pretty much all their mental health institutions, and you have a fallout of that. But I don't know, really. It's his attorney's like, oh, he worked for this business and he's an entrepreneur with that business, and the parole officer's like, I never heard of that. Those don't exist. It's like, where does she get this information from, right? If she paints this rosy picture, if you were to just hear from her, you'd be like, oh, this is a really good guy. Yeah, you should. What is he doing locked up? He's such a good guy. And but think about, again, I can't help but think about all the costs and the process. And in Connecticut, they do it differently than all these other states. Well, Utah does it like this as well, but I guess they don't give a public defender the way Connecticut does. And it's like his parole officer just wants him to. Can you imagine becoming a parole officer in the state of Connecticut? I think it's probably one of the most underappreciated jobs. It's like you're going up against attorneys. So first of all, you're going through the whole process where you have to monitor dangerous criminals. You carry a gun. You have arrest powers. Many of them are walking around with bulletproof vests, but they're not police officers. They're put in these crazy situations. No one, they don't get the same respect. No one says like, I respect you. Thank you for your service, right? And then on top of it, you're also like doubling as an attorney because you got to show up to these things, fill out these extensive forms. If you miss one thing or even put the wrong date, we see those things that those pieces of information thrown out, and you got to battle against an attorney. And meanwhile, everything you're doing is like right, like it's so clearly obvious. He just cares about his parolee, and he sees that the guy needs help, and then he's fighting against an attorney that's trying to pick apart your argument and filing process and documents. It's like, how much, who wants that as their job? It's like, I just don't like, why not just be a police officer, right? But yeah, it's a window into that side of things, isn't it? And let's see. So this we have Sir Richard and Lady Holly pulled information on this one. He has some interesting things. He has something where he sued the prison many years ago, and he claimed that a CO who is now a warden SA'd him or allowed someone to SA him. And he filed the lawsuit years later, like 20 years later, and the whole thing was thrown out of court. Basically what he said is that he said that this CO told an inmate to SA him, and they basically set it up and allowed it to happen. And when he sued, basically they just threw it out. They dismissed it and said, you have nothing here. This is ridiculous. You have no proof. You have no evidence. But I thought that was interesting. Like, this guy does, at certain points, he has been able to, at the very least, whether he was or wasn't, but see through the lawsuit, file it, get it done, and take it through the courts. In what way? And he does have a bunch of other crimes. This one is back. Let's see. This one is 2021. We could read through this one. Westville police pursue man by car and by foot. An officer used a taser to subdue a Hartford man this week after he fled from a motor vehicle, led police on a lengthy car chase, and later attempted to flee on foot. He was charged with first-degree reckless endangerment, reckless driving, engaging an officer in pursuit, possession of narcotics with intent to sell, and other crimes. The incident began at about 6:35 p.m. Sunday when an officer pulled Rose Green on Mill Street Road. He was unable to produce a license and initially gave the officer a funny name. When the officer returned to her vehicle to check information, he sped away. The officer pursued Rose Green, following him onto Silas Dean Highway and through a shopping center. Rose Green returned to Silas Dean and then cut through various streets, eventually ending up on Wells Road, heading toward Newington.
So I'm going to make a motion.
All the while,
to
Rose Green
grant
drove
parole
recklessly at a
on or
high
after
rate of speed.
his date.
After
So in the
crossing
matter of
River Road,
Lamont Rose
turned
Green,
down
inmate
Colonel
number
Chester Drive, which is a dead end.
279-980, I
As
make a
place
motion
number
to grant
1B.
parole
The two
on
of
or
the three
after
officers
September
pursued Rose
30th,
Green,
2024 with the following
tips,
conditions.
You're going to
Shot
Rose
fires
Green,
on
you want to
ladies trying
continue
return.
your hearing today, or
Rose
do you
Green
want me to
tried
push
to
you
drive
out 2
around the
weeks?
sticks and struck you.
No, you pushed me out in 2 weeks,
He
didn't you?
then fled on foot.
Oh,
You
yeah.
want a hearing today?
An officer
Yes,
located
today,
Rose Green
please.
behind the fence,
Okay.
unable to see Rose Green's hands and concerned about exposing himself by jumping the fence. Little did she know, right? The officer used a taser to subdue him. Rose Green was not seriously injured in the incident. Officers reported that Pepsi Cola and the Devil's Lettuce and hundreds of dollars in cash, as well as the Devil's Lettuce, was found in his car. And they learned that he was wanted on arrest warrants. What a nice guy. It's interesting. They paroled him so easily. They're like, okay, let's go. And then all of this happens, and he's going to be locked up for a whole nother year. And this is the part of the system that everybody needs to see. Everybody needs to see this, at least to understand it. Whatever side of the fence you're on, you got to see everything from beginning to end to actually understand Why? So it's not like, oh, why is this person locked up? Oh, he gets paroled and sent back on a technical. You know, you'll hear attorneys say this. Parole is so hard. We shouldn't have those conditions because we have people in our prisons for technical violations. And it's like, well, no. You don't have all the context. You don't have the full picture. You want the full picture? You can come see it. And thank you, Lady Holly and Sir Richard, for making it possible by connecting the hearings and the dots to make so we can line them all up. And if you want to see more like this, check out the Return of playlist. I'll put a link to that in the description. And with that, I'll let you go.